Get ready, start. A constitution bench of the Supreme Court on Wednesday continued hearing the submissions made by the Attorney General for India, Mr. R. Venkatramani, in Centre's curative petition against Union Carbide Corporation seeking additional compensation for victims of the Bhopal gas tragedy. During the course of the hearing on Wednesday, the court noted that in one of its judgments in the proceedings in 1991, it had directed the Union government to take out insurance policies for at least 1 lakh people so that it can take care of the future claims. However, it appears that the same had not been implemented by the center. A five-judge bench comprising Justice S.K. Kaul, Justice Sanjeev Khanna, Justice A.S. Oka, Justice Vikram Nath, and Justice J.K. Maheshwari commenced with the hearing on the matter on Tuesday. The primary obstacle that the Attorney General had to face was the slew of queries on the scope of the Union government's curative petition. The judges raised questions about center's intention to reopen oblique add on to a settlement which was arrived at in 1989 on the basis of subsequent developments. The Attorney General vehemently argued that in the present case, considering the enormity of the tragedy, the apex court ought to travel beyond the conventional principles to do complete justice to the victims of the disaster. Attempting to substantiate the claim for additional compensation on the ground that the settlement between the government and the delinquent corporation was based on an incorrect assumption of total number of deaths, injuries, and losses. The Attorney General concluded his submissions on Wednesday. The curative petition, which was filed by the Union government in December 2010, argued that apart from incorrect assumption of deaths, injuries, and losses, the settlement figure does not factor in the subsequent environmental degradation. As per the plea, the earlier figures for death was 3,000 and for injury was 70,000, whereas the actual figures for death is 5,295 and for injury it is 5,27,894. When the matter came up for hearing for the first time before this constitution bench in September 2022, it had asked the Solicitor General of India, Mr. Tushar Mehta, to seek instructions from Centre regarding its present stand on the curative petition filed by it more than a decade ago. In October 2022, the Attorney General informed the bench that the Union government was keen to pursue the curative petition. Accordingly, the bench permitted the Union government to represent the claims of persons who have suffered the Bhopal gas leak. So far as the other non governmental organizations were concerned, without foreclosing their right to be heard, the bench refused to grant them liberty to file pleadings. On Wednesday, at the threshold, Justice Call acknowledged the enormity of the tragedy. However, he made it abundantly clear that the court cannot afford to be guided by emotions. It does not have the privilege to play to the galleries. He added that though the Attorney General has time and again urged the bench to not delve into technicalities considering its unprecedented nature, every dispute ought to have a closure at some point in time. Even if the court is sensitive to the disaster that took place in Bhopal, it ought to bear in mind the ramification its decision would have on other matters. Stop.